Okay, well, thank you very much. Welcome back. We're just sort of playing around with some of the lighting. There's a lighting bar literally in front of us that sort of shines directly on us. We feel like we're at the wedding table. So we've toyed with turning that off for now. Having said that, the chandeliers seem to have 3 light bulbs working. So we're twiddling with a light for us to be practical. So anyway, so now please submit. I'll read out all your clients just once. So the Benson Farm Limited, Sitar 36 Limited, Shooting Box Limited, Atari Trustee Limited, PSC Yates Family Trust, and Waitaka Residents Association. If you're happy, I'll just refer to you as Benson Farm et al.
Hi.
And we'll hand over to you.
Thank you. Good morning, Mr. Chair, members of the panel. Appearing today on behalf of the submissions that the Chair has just read out. They've all been introduced to you in hearing 1, along with their properties. If you need a refresher of that, that's all set out in Mr. Hall's evidence from that hearing. We're here at hearing 4 today because the submitted properties are subject to various coastal or conservation overlays, namely natural character, outstanding natural features, and outstanding natural landscapes and coastal environment over all or part of those properties. So the overall submission of the submitters is that while the PDP is generally supported, amendments are required to ensure that the PDP adequately provides for coastal rural residential development and farming, including in the case of Ōmāpere and Ōmāpere, development that has already been approved. So submissions have been lodged on behalf of the submitters on this topic that canvassed a wide range of of issues with respect to both the provisions and the mapping or the extent of the various overlays. The submitters consider that the changes recommended by the reporting officers are a significant improvement on the notified version of the PDP, and that those will positively contribute to the overall workability of the PDP. And the submitters generally support the changes that have been recommended by the reporting officers, and many of which were sought by the submitters in their submissions. The submitter's position, though, is that further amendment is required to establish an appropriate natural environments policy and rules framework. And when I say natural environments, I'm using that term to refer to the overlays collectively. And the submitters say that the overlays need to be accurately mapped to correctly reflect the extent of the relevant environmental values, that there is certainty for development that have already been authorised so they can continue to be implemented over the long term, that the unique attributes of the various overlays that occur in the Far North District are properly recognised, that the role of farming in the Far North District is properly balanced with the environmental matters to be addressed by the various overlays, and the provisions are workable and do not impose unnecessary restriction or a regulatory cost burden. So I'm at paragraph 7 of my legal submissions, and I'll take that as read because that just sets out the position that sought by the submissions would then get to the legal requirements for state making. So the submitters intend to call 2 witnesses in support of the hearing 4 case, to be Mr. John Goodwin, the landscape architect, and Mr. Hall. I'll take that as read because they're both here to tell you what their evidence says and to ask questions about that. And I will try and move through my legal submissions relatively swiftly because really this is, the submitter's case is really a planning one, and I'd like you to have time to engage with Mr. Hall on those detailed amendments that he has proposed. So I'll set out the matters to be addressed in my legal submissions and then move to the first substantive topic, which is overlays and special zones. So the submitters have requested changes to the extent of the overlays and to the provisions in this hearing 4. Now, Ōmāpere Station and Ōmāpere and Benson have also made submissions that seek special zones to recognise the particular character and the desired development outcomes for those properties. Now, there are some comments in the Section 42A reports that indicates that such special zones or making distinctions for particular properties is not something that's favoured by the council officers. And so, although we're not in special zones here and yet, Matakira and Ōmāpere have been instructed to record their position on the relationship of overlays and special zones. So essentially, Matakira Station and Ōmāpere are large properties, the development, conservation and restoration of which has been comprehensively planned, and given that substantial investment that's involved in that and environmental consideration, it will necessarily be that these are implemented over a longer time frame. So for that strategic vision for those properties to be realised, it's essential that development can proceed as planned and realised. And existing and incoming landowners require certainty as to the overall form of development envisaged for these sites. Overlays that are designed to govern the types of development anticipated across the entire district can potentially be blunt instruments, and they're highly unlikely to properly recognise the planned and desired outcomes that are sought to be enabled for the submitted properties and exceptions to these provisions that may be warranted to improve environmental outcomes. From the submitter's perspective, a special purpose zone is a valuable planning mechanism for achieving this and for achieving this level of clarity as it communicates what can and cannot be done on the land. There's significant value to these submitters in having the relevant objectives, policies and rules pertaining to their sites contained within one place within the district plan, as it gives existing and incoming landowners real clarity as to what that can be done on their land and what their neighbours can do. We had some discussion this morning about when you look at all the potential overlapping arrays of overlays, you might come up with 14 different scenarios. So it's partly that trying to, when we're dealing with a large site, trying to really understand what applies and where, and having it in one site is a key reason that for the submissions relating to special zones to come in a subsequent hearing. So the other thing to keep in mind with that is that it is only the notified version and the decisions version of the PDP, and that will be issued after the panel has considered all of the submissions on the PDP. They're the only two versions that have legal status. What we're talking about in the interim is something of a discussion or a meeting. And so when we come to present submissions next year on special purpose zone, the intention is that it will be on the basis of seeking amendments to the notified version, regardless of the direction that the overlays appear to be heading in at this stage, which, as I said, is positive, but it's still only recommendations of the council officers. So the purpose of this is just a little bit of a heads up of where we're going in the relationship of the submitters case across different chapters of the PDP. So turning now to the legislative framework, look, you've already heard from the council officers on this. It's set out in the Section 32 overview report. We've heard from it again this morning. So I think I can take paragraphs 13 to 16 as read and paragraph 17. And then I'll just make some comments starting at paragraph 18 in terms of the matters of national importance, because they are very pertinent to what you're considering. So in paragraph 18, I've set out what I think are the three most important matters of national importance for this hearing, which is the preservation of natural character and coastal environment, protection of outstanding natural features and landscapes, and the protection of significant indigenous vegetation and significant habitats of indigenous fauna. So the panel's responsibilities and councils under Section 6 are to protect these environmental values from inappropriate subdivision, use and development. And I'll come back to that notion of inappropriate development later when we talk about the application of this to the submitted properties. But in terms of the law on this topic, Section 6 does not give primacy to preservation or protection, and it's not an absolute imperative overriding other objectives of the RMA. It simply requires that provision must be made for preservation and protection as part of the concept of sustainable management. Our particular planning instrument may give primacy to preservation and protection in particular circumstances. Recognise and provide for is not the protection of the things listed in themselves, but insofar as they have natural character. And what is inappropriate development is determined by its effect on the characteristics and qualities of the values sought to be protected, and it is possible for there to be appropriate development. Although the preservation of natural character is included in Section 6, this does not contemplate the reinstatement of a degraded environment as a matter of national importance, but that is relevant under Policy 14 of the New Zealand Coastal Policy Statement. And the identification of a natural landscape as outstanding does not preclude further development. Rather, again, it's protected are those values that qualify the landscape as outstanding. So at paragraph 20, I've just explained the difference between avoiding adverse effects and avoiding significant adverse effects, and there's a helpful table that was given by the council officers this morning, which essentially is saying the same thing. And then in terms of actually assessing those environmental values, the Court of Appeal has held that the correct approach is to first ask whether the land has attributes sufficient to make an outstanding landscape, which requires a factual assessment based on the inherent qualities of the landscape itself. Questions as to what restrictions apply to that land identified, they come next as a matter of planning, and a similar approach has been adopted in relation to significant ecological areas. So it's sort of common sense. You need to first identify where those values are before you decide the planning restrictions. We have case law that says that in relation to natural landscape and significant biodiversity. We don't yet have case law that confirms that for natural character, but if you, in my submission, it makes sense to apply the same approach. Often the case where I'm expecting to get some case law on that out of the Environment Court in the next little while, but I can say that all the council who are involved in it will agree that you ought to apply a similar approach, which does not have case law confirming that in relation to natural character. In paragraph 22, in relation to significant indigenous vegetation and significant habitats of indigenous fauna, significant requires judgment as to those natural resources in a district which need to be protected. Significance is not to be determined on a purely quantitative assessment, but on an element of relativity. And I'll set out there the evaluation criteria. Many of those do include that element of relativity, the representativeness, diversity and pattern, relationship between more natural and less natural areas. So there's very much a comparative element, a relativity element to assessing indigenous biodiversity values. And I'll take paragraph 23 as read. So paragraph 24, I'll set out the relevant parts of section 32.1. I'll take those as read as well. So at 25, in relation to assessing the efficiency and effectiveness of the provisions and achieving the objectives, the panel's evaluation must identify and assess the benefits and costs of environmental, economic, social and cultural effects that are anticipated from the implementation of the provisions, quantify these benefits and costs if practical, and assess the risk of acting or not acting if information is insufficient or uncertain. And that requires a value judgment as to what is the most appropriate when measured against the relevant objectives. Appropriate means suitable, doesn't mean the most superior method. And the tests in section 32 are to be read in the context of part 2 of the RMA, particularly enabling provisions of section 5.2. And so just draw your attention to what the Environment Court has said in terms of considering the benefits and costs of the alternatives. Leave you to read most of that quote apart from the last part, which says section 32 is a procedural provision that must be applied in accordance with the purpose and principles of part 2. The principles include the requirement in section 7b of the RMA to have particular regard to the efficient use of the relevant natural and physical resources. So there is a very important efficiency and regulatory burden of considerations that need to be taken into account as part of the panel's decision making under section 32 of the RMA. Set out the requirements of section 75.3 there at paragraph 28. Again, I think that's something that's been already canvassed this morning, but I don't need to take you through in any detail, and I'll also address this in my hearing one submissions as well. Turning now to the relief, the reasons for the relief sought. Now, there's been a lot of detailed relief that have been sought through the submissions and through Mr. Paul's evidence, but what I'm trying to do is pick out the key themes to address you on those before handing over the detail to the technical experts. So, applying the approach to ONLs and MAD war that I've discussed earlier today, correctly identifying the relevant environmental attributes and the geographical extent over which these attributes have values that qualify them as high or outstanding natural character or outstanding net is a fundamental starting point for the PDP's natural environment chapters. Just a factual assessment, and in most cases will require technical expert evaluation to ground truth the extent of relevant environmental values. In relation to the submitted properties, these are large properties with complex individual landscapes, and the area-specific natural character values vary across the properties, so it's particularly important that this factual assessment is carried out accurately. So I don't think there's really any disagreement in terms of the approach that needs to be taken here. Ms. Absalom engaged for the council to give effect to that evaluation that needs to be done. We have had some discussion about how this works in terms of the regional policy framework. So what's occurred here is that the natural character and outstanding landscapes have been mapped at a regional level, and that's what's shown in the RPS maps. And although that RPS mapping is a structured exercise following a prescribed methodology to identify areas that meet the criteria for each overlay in Appendix 1 of the RPS, any mapping at a regional level is necessarily high level. And potentially, as Councillor Foy indicated, potentially quite dated at this point. But that mapping has formed the basis in the notified version. But the RPS does specifically contemplate that a more fine-grained analysis and site-by-site assessments will be required at the district plan level. That's where we come to today. So I've set out for the panel the key policies of the RPS that provide for that more detailed assessment at this level, and I'll take those as read, but they're there for your reference. And in my submission, refining the overlays to better reflect the extent of environmental values on the ground as part of the PDP approach is consistent with the approach of recognising and providing matters of national importance as not protection of the things listed themselves, but insofar as they have natural character, because this process better helps the panel identify where those values of natural character are. And it will better give effect to the policies of 13 and 15 of the New Zealand Coastal Policy Statement that require the identification of natural character and landscape values, and give effect better to the RPS that does contemplate the further fine-grained assessment and ground truthing. So in that regard, Mr. Goodwin's evidence has proposed refinements to the proposed mapping the natural character overlays to remove areas of natural character on 4 of the properties. Mr. Goodwin largely concurs with the advice given to council by Ms. Absalom, and essentially they both agree that the identified areas of lawn, paragraph 7 ought to be lawn, grassland and minor scrub do not meet the criteria for identifying natural character values in Appendix 1.
Can I just ask a question before we move on to the next bit? But this, the policies you refer to in the RPS, can you give us your legal opinion? Is this is it a directive policy about refining your district planning overlays, or is it an enabling provision? In other words, is it may provide further detail, or is it shall undertake provide further detail? I'm trying to understand whether the RPS is directing or encouraging or enabling.
I would say it's probably enabling, and Mr. Hawley had a different, don't take the time to speak up. I say that because there's quite a lot of interplay, the way it's structured, there's quite a lot of interplay between the actual policies, and there have been very large sort of sections of explanation And so when I read those overall, I think it's more enabling by saying, they're saying that you must do this. I still make the submission that doing so and taking advantage of those enabling provisions would help to better give effect to the RPS overall, because it does contemplate doing that fine-grained analysis at this level.
So a territorial authority could rely on the RPS mapping. Or is the RPS saying, here's our mapping, but we're expecting you to do a little bit more?
Well, I was giving some thought to this when I was listening to the questions that were being asked earlier today, and where I got to, the panel has dual responsibilities here. You need to give effect to the RPS, and you could probably quite easily do that by saying, well, here's the RPS mapping, we've given effect to it. But you've also got your responsibilities under the New Zealand Coastal Policy Statement, where you need to, identify those values. And I think that's where the panel might have a little bit more challenge in terms of just relying on what's been mapped in the RPS. I think the pathway to reconciling that is these provisions that enable you to look at what's there on the ground now and what might have changed.
Yeah, okay, yeah, that sounds fair enough. But I suppose the RPS would be just as captured by the NZCP as a territorial authority, wouldn't it?
It would.
So in other words, the regional policy statement is just as obliged to give effect to that policy, the NZCPS as a territorial, or is there a stronger duty on a territorial?
It's the same duty found in different parts of the legislation,
yes,
essentially.
And is there potentially different functions that would require you to address that NZCPS policy different, or do you think it's a pretty similar approach?
I think it's fairly similar. You do have obviously different functions for regional and territorial authorities, but at this level it's one of those ones which is sort of grandfathered through at each stage, and have a cascade and hierarchy of planning instruments. And obviously with a regional policy statement, you're doing things on a region-wide basis. And so that's where you'd say, okay, I've got to map the whole region. What's reasonable to give effect to that in this context? But when you're at a district plan level and you're hearing submissions about individual properties, you certainly get scope to think about those individual fine-grained analysis from the submissions that are lodged, but also just simply because it is at a district level, you're at that more fine-grained level anyway.
Yeah, I certainly understand that. Okay, thank you.
So turning now to significant natural areas and the NPS on Indigenous biodiversity and the plan change process. Now you've now had Mr Fisher's memorandum on behalf of the council, and he's also taken you through that. My legal submissions address similar issues. They refer to the same case law, and we largely reached the same position. We've obviously gone through our analysis slightly differently, but I don't think I need to take you through all of that. I think a couple of points I wanted to emphasise was that it is clear from the NPS document itself that it's to be implemented through a series of plan changes over the best part of a decade, and it anticipates that councils will identify areas of significant Indigenous biodiversity on a comparative district-wide basis, and that plan changes in consultation with landowners will follow to designate those areas of SNAs. And I've used the same language as Mr Fisher at paragraph 39 about it's important not to be premature or to preempt the planning process, so that's clearly contemplated. And in my submission, that's because doing so would risk creating SNAs without the full comparative assessment of the district-wide Indigenous biodiversity values or consideration of how that should apply. And in my submission, that would be at odds with the case that I've discussed above about that comparative and relativity basis for assessing Indigenous biodiversity. So turning to the PDP's notified approach of having a voluntary mapping, I've set out there, I agree with what the analysis that was undertaken by the reporting officers in the Section 42A report. I've largely summarised all what they have said there. So my submission of voluntary mapping would preempt the consultation process envisaged in the NPSIB that's designed to be fair to the landowners, ensure that the areas of SNAs are considered on a relative and comparative district-wide basis. I won't say that that would be a negative and costly outcome. We can't meet statutory tests under section 32A of the RMA of it being the most appropriate, effective and efficient option. So what the submitters ask is that the recommendations of the reporting officers that the panel adopt those. I'm happy to answer any questions about this. It's obviously something that appears to have been on the minds of the council. But I think really the point that I'm making is that what's proposed by the council officers is sufficient in my submission to give effect to the NPSIB, notwithstanding that that may change, and that there's an interim position where you need to do what's reasonably practical. What's proposed will meet that, notwithstanding everything that may come great deal of uncertainty in the future.
Let's see if there's any questions on this matter.
Well, the only question I've got is the interim measures, are they going to have enough teeth to satisfy the legal requirement, I guess? And you're saying they are.
I'm saying that they are, because there's still quite a lot of sort of recommendations and things and references to Indigenous biodiversity. And I suppose the other way you can put that question is, if you're in a position of not having the SNAs mapped, and that's not going to happen for some time, and not going to do that comparative, what more can you do to give effect? And I think that's probably where the recommendations of the officers are sitting. There's nothing that immediately springs to mind, those sort of glaring omissions or anything of that nature, and that might be as far as I can take that.
It's a bit of a sticking plaster kind of until.
But it's not perfect, but it's a dynamic regulatory and policy environment. So,
thank you.
A supplementary question to that, relating to the precautionary approach and the recommendations of the officer to decrease the area of vegetation clearance from, I think, 5,000 to 1,000, or to decrease it. And not being relative to the title or land area. For example, 200 hectares or 1 hectare sites, or if the site has got 100% site coverage of vegetation. Is there anything that you've picked up in terms of what's been recommended relative to, as you said, ground truthing and practicalities of it?
not in relation to sort of submit specific properties. I haven't looked at it. There's so many different scenarios we're talking about based on site size and that sort of relativity. I probably can't comment generally on something that's going to affect other different implications across the district. So,
I don't think there's any further questions, thank you.
Turning to farming in the CEL and ONL, this is a very key issue for the submitters that I'm representing. And so, notwithstanding that there's been a really positive change in that regard in the Section 42A report, I've been asked to address this matter to urge the Commissioners to adopt that approach. So, the notified version of the PDP proposed requiring non-compliant reasons consent for farming. And if there's be a change in the character, intensity, or scale of farming, then that rule would be triggered. And the submitters are strongly opposed to that approach and support the Section 42A report recommendation to make farming a permitted activity in these overlays. So in terms of the requirements for district plan making discussed above, it's submitted that there's a need to strike an appropriate balance between protection of natural landscape and features under Section 6 and ensuring that the plan provisions are appropriate, effective and efficient and give effect to the enabling component of sustainable management purpose as required under Section 32 of the RMA. The Farnworth district is extensively rural and pastoral, and farming activities make a significant contribution to identified landscape values. It submitted that in this context, a rule that requires consent for farming activities would afford unwarranted primacy and protection of natural landscaping features, act as an unwarranted veto on an anticipated land use, and would be costly and inefficient and contrary to Section 32 of the RMA. Such approach would also be contrary to the sustainable management purpose of the RMA of enabling people and communities to provide for their social and economic well-being. Further, it would be inconsistent with the strategic direction chapter of the PDP that recognises the importance of rural production activities to the district, and with the Far North 2100 strategy document that recognises the very significant contribution that farming activities can make to the economic prosperity of the district. Turning to the objectives and policies for the overlays, I've got a small correction to make on paragraph 49, which is just to delete the words at the end and supported in the section 42A report. And then I'll just speak to this. Essentially, the PDP talked about just as notified characteristics and qualities. The officers have recommended adding in values. That's something that's supported by Mr. Hall. He also recommends including that at a policy level as well, to take a balance and braces approach. But I'm starting to get to those levels of details where I'll leave that to Mr. Hall to discuss further. Next topic to address you on is buildings and extensions and approved building platforms as a controlled activity. Now, this is something that's quite a key issue and essential for the submitters that I'm representing, particularly for Ōmāpere Station and Ōmāpere. So, naturally, a purchaser that's buying a lot in a subdivision with an approved building platform has a legal expectation that they will be able to build on that lot. In addition, there are strong benefits to controlled activity status in terms of incentivising quality development outcomes. So fundamentally, the natural environment overlays are a mechanism designed to ensure that the adverse effects of inappropriate subdivision, land use and development are managed. And my submission, the converse of this involves making sure that the PDP is properly set to encourage appropriate development. And I submit that this would require environmental decision makers to recognise when a development approach achieves quality, economically, socially and environmentally sustainable development, to understand the drivers of these desired outcomes, and to ensure that the policy settings and plan provisions properly address these drivers to incentivise the desired outcomes. The submitted properties have accomplished and can continue to sustain this level of quality development, and it's important that the policy settings in the PDP support and incentivise these outcomes. So in terms of the drivers of these outcomes, restoration and conservation do not just happen. And it's important that decision makers do not ignore the cost of achieving these desired outcomes, how these outcomes are funded and by whom, and that restrained and quality development plays an important role in funding these outcomes and can be an enduring source of conservation funding, including through changes in economic conditions. And so I think I'll just pause there to say, this is one of those sort of, we're meeting the policy with what actually happens and how restoration and conservation happens on the ground. So at Ōmāpere Station, for example, just maintaining the level of conservation planting that's there costs around $1 million a year. And that's before you have capital outlay to try and extend and improve those areas. So it really is a very substantial investment. And there needs to be, in the plan, recognition of how this occurs. For example, there at Ōmāpere, there have been proposals which would have seen hundreds of lots on either that site or the site next door, rather than the small number. And so you're looking at a very different environmental outcome. The direction it's gone, a positive one, I would say. But there has to be a recognition of how that's been achieved, and it's through very well planned developments, limited subdivision, and that's what funds this and enables it to occur. You know, the far north is, you're seeing driving up, very fertile environment for weeds and gorse. And it's not, these outcomes are not something that just happens. We don't just fence off things and then we have a naturally integrated environment. That may be the outcome, but that's a very, very long-term approach to get there. If you want positive outcomes and you want those to happen at a faster rate, then you need to think about how to fund that and how we incentivise it. And so what lies behind this call for controlled activity status is about certainty, and that certainty of development enables values to stay high, and then that's what funds the restoration. So that's the driver and the thinking behind the submission. It's a little bit sort of convoluted and circular, but I think that's the point. It is very interdependent and very interrelated. And so at paragraph 58, what I said is realistically achieving these type of exceptional quality rural living developments go beyond, the time frame to implement goes beyond the life of any particular district plan, which means that the PDP needs to properly recognise aspects of these projects that have already been consented. And that need for certainty that the buildings can in fact be constructed on building platforms approved under existing subdivision consents, as well as subdivisions, it's not just consents here, it's consents that have been, it's consents that are existing, but also those that have been implemented and still haven't been built on yet, so consents and implemented subdivision consents. And what there'd be significant sort of certainty would be provided to the submitters in knowing that an application cannot be declined. But also there's value in the other direction, in that there's value that there are caps on future development which are designed to avoid environmental creep over time that would alter the established character of the properties. And so certainty that building can occur and where, and the spacious and exclusive character of the environment we maintain is a key driver in the properties retaining their high value, and then the ability to fund those conservation outcomes. So it follows that retaining this required level of certainty requires that buildings or extensions of approved building platforms need to be a controlled activity, but then buildings outside of those are assessed on a more rigorous basis. That's that incentivisation aspect. Further, the matters that are controlled need to reflect the level of landscape assessment and design that has gone into identifying and approving these building platforms in the first case. It's important that landowners have confidence that the scope and nature of any conditions will be reasonable and reflective of the level of assessment previously undertaken. And this is achieved through controlled activity status, as council power to impose conditions is restricted to the matters over which control is reserved. So I've set out there the amendments that the submitters support, and they ask the panel to make those amendments as set out in Mr. Hall's evidence.
Just in terms of your 63 brackets B, having specified and limited suite of matters of control rather than a broad and open-ended assessment, etc. Are you providing something that you see as appropriate?
Yes, so Mr. Hall's evidence has set out what he thinks that should be. Broadly, the issue there is sort of what I just said about certain matters of control. Yeah, and so yeah, we are proposing something specific. And then just a point on notification of controlled activities. There seems to be agreement generally between the planners for the submitters and reporting officers that ought to be non-notified. The only difference is whether or not you include a rule in the district plan to say that notification is included. We're suggesting that that would be appropriate just to provide greater certainty, because legislation and program, we're on a path of reform, we never quite know, so it would be better to state it in the plan. In terms of the approach to buildings and extensions outside of approved building platforms, I'm going to leave this to Mr. Hall, because this is really about a nuanced planning approach to try and get the balance of this right. And then I'll take you to my paragraph 73 on the workability of the overlay provisions. Again, now we're getting into those sort of matters of planning detail. Mr. Hall proposed changes to a number of provisions relating to indigenous vegetation clearance, earthworks, colour, materials, rules, building height, and provisions for maintenance of domestic gardens. The issue here is about having the right balance between enabling land use under the PDP and the council retaining control over these activities at the resource consent stage. In my submission, the effects of these activities are generally well understood and capable of being managed upfront by rules and assessment criteria in the PDP. The suite of provisions recommended by Mr. Hall provide greater certainty about what can and cannot be done and strike a better balance between flexibility and control, and are more consistent with Section 32 of the RMA, applying in accordance with the Part 2 principle that requires that particular regard be given to the efficient use of the relevant natural and physical resources. And just in terms of this point relating to the maintenance of domestic gardens, the submitters have made significant investments in curating gardens at the curvilages of residential dwellings. This is particularly the case at the Shooting Box and Gate family properties. And these gardens involve extensive native vegetation planting and have been designed to seamlessly integrate with surrounding natural character and landscape areas. However, they remain domestic gardens and should not be treated as having natural character and enhancement values. Landowners need to know that they can undertake cycle planting using native plants around their houses to improve their amenity and enjoyment of their properties, and be confident that they will be able to alter that planting in the future. Any alternative approach would have the perverse outcome of discouraging such native planting, which is not a desirable environmental outcome. In conclusion, the submitters say that the amendment sought will improve the clarity and coherency of the PDP and better fulfil the statutory district plan making requirements. The amendment sought provide the most appropriate way to achieve the purpose of the RMA for the reasons that I've just discussed. The submitters asked the panel to approve the amendment sought by the submitters as set out in attachment 2 to Mr. Bruce's statements.
Thank you. I think we'll just see if we've got any questions related to your legal submissions before we move on to the questions.
Yeah, I've just got a couple, there's a clarification and one question.
Yep.
Thank you for your legal submissions. Paragraph 31. Is there a typo there in the sort of fourth line down? You're talking about outstanding natural character twice. Should the second one be outstanding natural landscape?
Yes.
Cool, thank you.
Yeah, but this is this issue that I sort of discussed as I was going through the legal part. Is at the moment we do only have it applying to outstanding natural landscape, but in my submission it should apply to both.
Yeah.
So it should read both.
Yeah, cool, thank you. Paragraph 11D. I think I've got my head around this now, but I just want to hear it from you. You mentioned checks on neighbours. This is the special purpose zone place. Mention gives existing and incoming landowners what they can do on their land and what neighbours can do on their land. You're talking about neighbours within the
special purpose zone, yes, but it would apply more broadly. But the concern that I'm addressing here is about within these rural lifestyle developments,
right?
And that leads into what I was talking about later about avoiding environmental creep and the importance of maintaining high values. So. But it is relevant. Everybody is always interested in what their neighbours can do over any extent under the RMA. So, I'm making this about within that area.
Great, thank you. And then just this really is on the national planning standards. You touch on it in your submissions, but you don't really go too deep into it. There is discussion in the officers' reports about, for example, the title of we've got natural features and landscapes, and some other submitters have said it should be outstanding natural features and landscapes because that's all that's addressed. this chapter, whereas the national planning standards are a bit wider than that. They're talking about other, not just outstanding natural landscapes and features. So
It's not something I've considered specifically, and I think I'll just say I'm not really able to answer it, because those national planning standards, they're very detailed, and unless you've sort of specifically considered how it applies in any given situation, it's not something I can really just make a general comment on.
sorry, I put you on the spot a little bit there.
Mr. Hall might, okay.
And I'm really asking it to signal that there's a question that might come to the council officers later on.
Yeah.
Okay, thank you. That's all I have.
This whole question of controlled activity and restricted discretionary activity, and what are the legal limits of controlled activity? This has been there's been a lot of discussion about these things. Can you just remind us as to it seemed to me that local authorities moved away from using controlled activity because it didn't give them as much control as they thought it did. And then I think that the case law has evolved to sort of constrict what you can do with a controlled activity as opposed to what was being applied in the early years of the RMA. In terms of your legal opinion, can you give us a legal opinion as to what the limits of a consent authority are when they are using a controlled activity status?
Yes. Okay. Look, I think it.
I mean, they can't change an application, can they?
No. No, I mean, regardless of what the activity.
You can't say, we don't want that driveway there, we'd like it over there. You can't, controlled activity couldn't
If you
change
take
it.
it back to the fundamentals, a consent authority needs to assess an application that's before them. For a controlled activity, that means they can impose conditions, but they can't decline it, but also that what they can impose conditions on is restricted to the matters under which council has reserved control. Now, you can look, there may be matters relating to where that driveway goes, where you're saying, it needs to sort of tick these environmental boxes, it needs to blend in, and it needs to be of these materials, but they should be things that your consenting officer can just tick. Does it comply with these standards? So we shouldn't be getting into broad-based policy situations.
Or have the effect of essentially declining it by ways of control.
Yes, it shouldn't be, it's not supposed to be, you're not supposed to set up your district plan in a way that essentially turns it into a restricted discretionary application. It's designed to, to have those, it's the most simple consenting pathway that you have, other than being a permitted activity compliant with development controls. It's supposed to give certainty to both the council and the landowners in terms of what they can do.
Okay, thank you for clarifying that. Now, just who's going next?
Mr. Goodwin.
Mr. Goodwin's next. Sorry,
Short, sweet, hopefully. Mr. Chairman and Commissioners, I think we're in the afternoon now, so good afternoon. So I've only got a very short statement, which I believe you will have seen and read. And what I was going to do was just step you through the different sections quite quickly. A lot of my input has been working with Mr. Hall in terms of the provisions, and so you may have some questions about my evidence, and I'm happy to answer those, but there may be some things that come through when Mr. Hall talks about his recommended changes to the provisions, which I've had some assistance with. So I'm happy to answer questions now or later.
Well, I suppose the simple question is, are you happy with the changes that Mr.
Yes, and I say that in my conclusion. So,
well, I suppose what we're also interested in is the difference of opinion you have with Ms. Absalom.
Right.
And how you've reconciled those differences.
Yeah.
And we may ask Ms. Absalom to respond to your evidence today while we have her in person.
Yeah. Okay, well, I'll take you through those sections as I've suggested. Paragraphs 1.7 paragraphs 1 to 7 set out my qualifications and more general experience. In paragraph 8, I outline my specific experience in, I guess, relation both to the far north, but also in terms of working with these types of overlays in the far north. And 3 of those properties, 3 of our submitters properties, so Ōmāpere subdivision, which is part of Benson's Farm, which I had quite a detailed involvement in the site planning and working through the management plan provisions for that, as well as an overall management plan for the property. I mentioned Carry Cliffs, which is not one of our submitters, but that's another property that I'm also more recently been involved in. Matica Station, I was involved in the stage 2 planning, and obviously they're one of our submitters, and also Ōmāpere for the Ōmāpere Trustee Limited. And as I said, in relation to this process, as well as assisting Mr. Hall in particular, I have reviewed the provisions and recommended changes in section 42 report, but then also reviewed Ms. Absalom's report and in particular her recommended changes to the overlays, the high and outstanding natural character, and also the coastal environment, and then undertaken a more detailed site visit to most of the properties. 2 of them I hadn't been to before, which is the Shooting Box and the Yates property, whereas the others I had been to previously as part of my projects. And as part of that work, I've also prepared some maps, and so I'll come back to those when I talk about the overlays and the changes to some of those overlays. So I'll take you to that section on mapping. Well, Sarah starts with paragraph 13. So in essence, I agree with Ms. Absalom in terms of the changes she recommends to the mapping areas. And, you know, I guess I've had the benefit of having being able to have a look on those properties and ground truth, in which Ms. Absalom admitted that she hadn't been able to do. She'd done it through photographs and visits to public roads and things. So that was really helpful. And as part of that process, also had geo-referenced plans with the council's overlays, the regional council and the district council overlays on them in terms of the coastal environment extent, the outstanding and high natural character areas, and the outstanding natural landscape areas. So that was really helpful. And then mapped on the areas that Ms. Absalom had recommended be deleted, and then looked at those on the ground with a geo-referenced plan on an iPad, which is still not 100% accurate, but it gets you with anywhere between kind of 5 and 10 metres away, so it's pretty good. And so yes, in summary, those 3 properties, CETA 36, which is on Ōmāpere Island, and the Shooting Box property and the Yates Family Trust, I've agreed with Ms. Absalom's recommendations and recommend that they be amended to remove those areas of either lawn, but predominantly lawn. One of them is a little bit of kind of scrubby vegetation in there as well. And if the council wanted any more detail on that, the maps that I have produced could be provided to the council because they are GIS referenced, so the geo-reference plans. So, and then the 4th one was the coastal environment boundary on the Ōmāpere Trustee Limited land, and likewise there's an area there which is I agree with Ms. Absalom, is outside of the coastal environment. and that should be amended in my opinion. Just picking up quickly on this vegetation management issue, and certainly those two properties, the Student Box and the Yates properties, it was evident that they've spent a lot of care and time developing indigenous gardens, or gardens that have predominantly indigenous plants in them, and a lot of them are actually adjacent to outstanding or high natural character areas, and they're beautifully maintained. But those planted gardens are different to naturally occurring character areas, and in my view, they should be able to maintain them with a degree of flexibility that suits those kind of garden environments, as opposed to being a more natural environment. The height limit one, I once again concur that a 5 metre height limit is an appropriate starting point in the outstanding landscape and coastal environment. I think there does need to be some flexibility beyond that, and I guess using my experience both at Ōmāpere and Matuka. So Ōmāpere has a range of heights that were recommended through the management plan process and at through the consent process between 4 and 6 metres. And that very much depended on the location of those house sites. 4 metre ones on very quite prominent small peninsulas, and they were deemed to be much more sensitive than ones in the valleys, which were 5 metres, and then a much bigger valley where there's one that's 6 metres. And same with Matuka Station, they're a combination of 5 and 6 metres. And they've been determined through quite a detailed process of assessment. So really understanding the topography, the relationship to the coast, the backdrop and vegetation as well. So I believe that 5 metres is a good starting point, but I think there should be the opportunity through some form of discretion to allow for further height with appropriate mitigation. And I take the example that I think the key issue is, and I've said it here, what should be avoided is having an unrelieved two-storey face, particularly on the coastal environment. And so that's a balance between cutting a building into the earth and having it sticking out on a sloping site. And a lot of these sites in the coastal environment are sloping. And sometimes you can have a building which is a single level building, but it may have an undercroft. And in those sorts of situations, it's important that there is mitigation planning which really ensures that the building reads as a single level building. So there are techniques around that, and I think that's where the district plan needs to make sure that they are provided for with the appropriate consent application and certain conditions. So that's a bit different to the controlled activity status, but if you want to go beyond those height limits, I think they should be permitted with the right mitigation. And then the last couple of sections are really just around the design controls and assessment criteria. And as I said, I've worked with Mr. Hall. He's come to me and asked my opinion on certain things, and I've provided it. So, but with that as a proviso, yes, I do support the recommendations and his evidence. So that's, I'm happy to answer any questions now or later on.
Well, we'll see if we've got any questions for you now. Thank you.
Yeah, just one if I can, Mr. Goodwin, just in those areas of high natural character and outstanding natural character, there's a number of buildings feature in some of those areas, like houses, for example. I mean, is that something you generally expect in one of those special areas?
Yeah, not many. In those areas, in the high natural character areas, they're very subservient, so they're almost not identifiable in my experience, certainly on our submitted site. And I don't think there's an expectation for buildings in those areas, because I think the kind of biophysical characteristics and qualities of those areas are very strong. The regional council's study, the approach taken for natural character, was very much based on biophysical. I think Ms. Epsilon also outlines that in her report, that it's landform and vegetation primarily, as opposed to landscape, which has a broader suite of understanding, the characteristics and qualities, which can include pasture and buildings and other elements. So, and I think that's a good distinction, in my view, that we maintain within the district plan, because I think it's very clear, and I think some plans perhaps muddy the waters there a bit, and we get this kind of overlap between natural character and landscape character. And I think it's good to keep those, an understanding of those quite separate.
It's probably a realistic approach, but I mean, if you look at the CETA 36 property on Ōmāpere Island, then the building's quite conspicuous, particularly from the public realm. Looking, I mean, I've not been to the site, I'm just looking up there with photographs. But as I take your point that it's only a detail in the...
But that's in the outstanding landscape, but it's not in the high natural character area.
Right, okay.
And so that's the distinction.
Yes.
So agree that it's still in the outstanding landscape, because the landscape there is much more dominant.
Yes.
It's one building and a pretty much a large portion of, a few buildings, and a large portion of an island, which is predominantly natural, as opposed to there being a more dominant. And but the change to that is to remove a piece of the lawn that was currently shown as being in the high natural character area, which Ms. Epsilon and I agree shouldn't be. So it's that thing about the vegetation, the natural vegetation, the occurring vegetation, or is it gardens, or is it lawn, or is it some other kind of scrubby vegetation which is of no value at all.
Oh, that's great. It's a shame that you have to be in agreement with Ms. Epsilon and everything, because she can provide some quite fiery responses.
We've had our battles before.
I have seen some of them. Thank you.
Thank you, Mr. Goodwin. I just have one question, because I thought your evidence was very clear, and it's really just come out of the discussion that you had today. And it's the role of design review committees, which I see in your evidence you're part of some of these properties. Do all of these properties that you were representing today have that sort of role behind the scenes?
Not sure about Ōmāpere does, I'm not on that one. But Manukau does, certainly, and I think it's those larger properties like Ōmāpere and Manukau Station where there's a number of sites like 25 at Manukau, for example, and they've developed over a long period of time. And yes, and the Residents Association there use the Design Review Committee, which I'm on that one, and I think it's a useful process so that a number of the design issues get ironed out before an application's made to council.
So I guess the follow-on from that is, given that this is a district plan-wide, district-wide sort of change that can go into place as the controlled activity thing, what if a property didn't have that sort of back of room design review committee thing going on? Would that be a problem?
Not necessarily. I think as long as those building platforms or buildable areas, and I use the two kind of interchangeably, because I think sometimes I use buildable areas, which is perhaps a slightly wider concept than building platforms, but as long as those have been identified and accessed as well through an assessment process, and then out of that there are a series of criteria that say, well, the building height should only be 5 metres, or in this case it might be up to be 6, and this is the level of mitigation you need, you meet all obviously all the colour requirements and reflectivity, etc. Then probably don't need a design review committee necessarily. It is a cost. And, but I think certainly speaking in relation to Matica, they see value in that and they're prepared to, to pay a small group of people to provide that, that initial review. And then, we have made changes, or have recommended changes to the architects.
Yeah. Okay, no, thank you, that's been helpful. No questions.
Thank you. Just one sort of question for you. We're obviously going to need to come and visit a couple of these properties by virtue not just of the evidence we're receiving today, but on the other evidence we're about to receive regarding the request for special zones. And you've talked about the circumstances where you've got gardens which are essentially native vegetations, but they're gardens, not native vegetation to be protected. Can you give us some examples which we could particularly focus on and as being an example of that? Is it the shooting box and the Yates properties, which would be the good examples of that issue, or are there other ones you would direct us to?
Well, no, those two in particular, the Yates property was the one that stood out to me. Just the care and the mix of vegetation, which you might not traditionally find in the more natural high character. Well, in fact, in front of their house is an area of outstanding natural character. And some, the species may not be purely reflective of what is in the purely indigenous areas of high or outstanding natural character, but they're managed gardens and they're quite clearly managed.
Yeah. I was going to say, would it be readily apparent to the likes of those members of the committee who aren't landscape experts?
Oh, you've got one with you.
Don't say excluding maybe just need to make
yeah, I think so.
I mean, would it be really apparent?
We went together, and I don't think I had to point anything out specifically. It's pretty clear.
Because I've been and seen them recently for the first time, and as soon as, particularly the Yates property, as soon as I got there, it was very apparent what Mr. Good and Mr. Hall had been trying to educate me about before I got there. So.
Right, okay, no, okay, that's fine, that's quite up. Well, thank you very much for your evidence and your answer to our questions today. How are we going for time? Oh, we're going quite well. So we still have you right through till 1 o'clock, so I think that gives you plenty of time.
Good, thank you very much. I'll take my time. I have to rush. Yes, I do. So I will just start with an amendment to a couple of amendments to my evidence.
Yeah. Are you going to summarise the evidence, or are you going to give us? Do we have a summary statement?
I'm going to summarise the evidence. So attached to my evidence appended attachment 1 is a summary statement, but that goes through both areas of agreement and disagreement, and I really just want to focus on the areas where there's still remaining some areas of disagreement, and effectively those are around issues of refinement, I suppose, with the report. So I want to focus on those topics.
I just want to stop you now. Actually, I just read my note for myself, but I didn't read it before. I was going to give Ms. Absalom just a chance to respond to Mr. Goodwin's evidence. Only because she's here in person, and I like to take advantage of somebody who's actually here as opposed to on a TV screen. So, have you got any response that you'd like to give us in response to Mr. Goodwin's evidence?
Thank you, Mr. Chairman. I guess the first thing to say is thank you, John, for agreeing with most of what I say. He is correct in saying that he's had the advantage of visiting these sites and I haven't. That has not been something I've been able to do. And therefore his confirmation of my recommendations made purely with the use of a computer is reassuring to me that I'm probably not too far wrong in most of what I've done is my response, because I've had someone go and check it for me. I don't think there's anything else I need to say really, unless you had particular questions to me as a result of what he has said.
Oh, I just wanted to get a gauge as to the level of agreement that is, the level of agreement is what Mr. Goodwin says, so it seems to me that you both are. Everyone agreed?
The area where we, I think, differ is how the 5 metre height limit, which he says is a good starting point, is managed. Mr. Goodwin is looking for some flexibility. I am fully aware of the fact that a district plan is a fairly blunt instrument. Obviously, sites that have their own provisions, whether it's by way of a special area or whatever precinct, however it's managed, have the advantage of being able to fine-tune those broader controls. But nevertheless, those broader controls need to be there for those places that haven't got their own specific provisions applied to. And so I think the suggestion that whether we move to restricted discretionary activity or whatever, that is the way to manage situations where a control is seen as a starting point, and from there you need to go through some hoops to enable something greater to happen. And I would certainly support that in principle.
So you're happy with the activity status in principle? Obviously, we'll have to look clearly at what those measures of discretion are,
Yeah,
and what criteria you attach to them.
but that is an appropriate way to manage things.
Okay, no, thank you. That's yeah. So sorry for that sort of half-cold start, Mr. Ward.
I was just making a couple of corrections to my evidence. I'll start with that paragraph 9.8, Roman 3. That's just where I'm stepping through and talking about the combined effects of my changes recommended in the 42A changes. So Roman 3, 9.8, restricted discretion activity in the ONL, brackets inside, and I will just delete the words or outside the, and then the rest just flows. And at the end of that paragraph, and restricted discretionary in an ONL outside the coastal environment. I appreciate it's a bit taken, so I'm happy to submit that revised wording if it assists.
What's the second one again, sorry?
At the end of paragraph 3, add and restricted discretionary in an ONL outside the coastal environment, which is as per the 42A report. Effectively, I lumped the two in together, but there is a distinction in activity status within ONLs inside and outside the coastal environment. I just want to make it clear with that revision.
Great, thanks. Perhaps you could just give us a PDF of that page, maybe, and sort of like underline it.
Yes, certainly.
Put it on, and then we can, you know, we might not come back to this for a week.
Yeah, absolutely, yes. The other change, and this is just picking up on a discussion that Mr. Goodwin and I had about building platforms. We have both, I think in our practices, applied the terminology building platform and buildable area interchangeably. In effect, they're the same thing. That part of the site identified a subdivision where buildings are able to be built within. And so both in those control activity rules, control activity CER1, and I'll provide this wording, and NFLR1, so they're the two controlled activity rules I'm recommending adding on the building platform or buildable area, just to cover both. And I was conscious of a future argument, perhaps with a consents planner about you've identified a buildable area on the plan. This is about building platforms. So just wanted to cover both terminologies off.
Either of those terms defined in the plan?
Neither of those terms are defined. I thought that might be the topic question.
So there's no interpretive. So you're just saying they're synonyms?
Exactly. I think in lieu of a definition, I'm trying to ensure that activity status covers what is typically used, both the building platform and building area are used at subdivision stage interchangeably. The example I'll point on buildable areas on Merino, that is the terminology, very precisely defined buildable areas are mapped on the management plan.
And that relates to a consent.
That relates to a subdivision.
Okay, great, thank you.
Thank you. So, Robert, just as a bit of a roadmap, because there are a lot of very particular changes which I recommend my evidence. I'll take you to section 4.1 and over the page where there's essentially eight areas where I'd like to talk about. Some of these are policies, some of them are rules. As I say, these are really areas of refinement from what's been recommended. So, Roman 1, first I wanted to discuss the consideration policies. So, I think that's what they've been referred to in the 42A report. So, it's a shorthand for, in other words, that those policies say in considering applications, the following matters taken into account. So, they're the matters that set out the matters to be considered in policy. Some refinement there. Policy CE P6 in relation to farming. The new recommended policy in 42A, which is IBP6, I'm seeking some changes there, and that's in the Indigenous ecosystems, Indigenous biodiversity topic. 4 amendments to the proposed new clauses, natural control activity clauses, so in addition to the amendment I've just talked about, there's 4 other amendments recommending in relation to the control activity clauses. 5, proposed use of restricted discretionary and discretionary activity status in certain areas. We'll step through that. 6, the provision for additional exclusions for earthworks and Indigenous clearance rules. So there's 3 additional exclusions I'm proposing. 7, amendments to the natural character rules relating to lakes, wetlands and associated definitions. I'm picking up in particular actually earlier questions from the panel in relation to farm, dams and for water supply purposes. And then lastly, support for the mapping changes recommended Mr. Goodman, and we'll just be taking this read that part. So starting with the consideration policies, and just thinking the best way to, it's useful for the panel to be point some particular changes attached to my evidence in attachment 2 are the markups I'm proposing in red. Might be a useful starting point.
Attachment 2.
Yeah, attachment 2.
It's important. Now, one of the digital version of variants, which means I'll have to do a lot of scrolling.
Maybe if you suggest less rather than more, more manageable.
Suggesting. I mean, equally, I could just read through. I mean, you know the attachments there. I could read through my evidence, and you could go to it after, whichever suits.
Yeah. Okay.
So, turning to those consideration policies. So, at paragraph 5.4 of my evidence, I talk about policy CEP10, which is the consideration policy where I propose qualifying policy such that consideration is given to the natural character of the coastal environment when assessing the effects of land use and subdivision, rather than simply the coastal environment as drafted in the 42A report. And that's simply on the basis that it provides a better reflection of Policy 13 of the New Zealand policy statement, which is about the natural character of the coastal environment. So I think that's just a simple revision to follow through down into those policies. Probably one I want to talk about a little bit more is the next suggested deletion of a consideration matter H, which is any viable alternative location for the activity or development. So at the moment, the policy talks about the matters to be considered when looking at resource consent applications or other things, and one of the matters is any viable alternative location. And I'm proposing deleting that because that would require an assessment of alternatives. It gives no criteria against which to assess those alternatives against. So when considering viable locations, there's all sorts of things that might come into play in addition to the landscape matters. So financial viability, geotechnical viability, there's a whole raft of things. And I suppose fundamentally at its core, these policies are about coastal environment, natural character. So inherently in there is already an assessment of the appropriateness of a particular location. So there's no need for an evaluation of other viable locations. And it really, I suppose, puts the applicant in a position now to present an alternatives analysis. We didn't select this site because we didn't select that site because, and so in lieu of actually setting out what is the matters you should be weighing that evaluation against, it really serves no purpose. So I'm recommending deleting that.
Just to discuss that, I mean, obviously, I mean, this policy sort of serves almost like assessment criteria, and I suppose a processing planner might want to ask an applicant, did you consider alternatives? Do you think that if this was deleted, would a processing planner still be able to ask that question?
Yes,
or at least investigate alternative locations within your application?
Yes, they would, because one of the other criteria is the location. And so, in considering this location, the natural answer is this the appropriate location. It doesn't then say, go off and find me 5 other locations that are more or less appropriate, because in the applicant's response, that would be on what basis. I could go there, but that would be another 100 metres of road, or would be earthworks wouldn't work, or geotechnically unstable. So, viability then goes to, well, it would be a less preferable site from an economic viability perspective. So you get into quite a big discussion around viability unnecessarily when at its core the issue of location is still in the assessment matters.
Well, I suppose you've got the risk of going down like a rabbit hole of straw person type suggestions as the viable, non-viable.
That's right, and I think the other thing is pointed out in an RMA sense that assessment of alternatives comes into play on the significant adverse effects. That's when it triggers you into an assessment of alternatives under the fourth schedule of the Act. So that's still there for significant adverse effects.
Could you put that in to be explicit into this objective? Not the policy, into this policy. Could you put the significance, significant adverse effects? I think there are significant adverse effects. You look at alternatives.
I don't think it's necessary because it's part of it. It's what the Act says. The Act tells you to do.
Okay.
In presenting an application to the fourth schedule with significant adverse effects, you have to demonstrate alternatives.
Okay, thank you.
So that's probably the key one I wanted to discuss there. Then turning then to the equivalent policy NFLP 8, which is the consideration policy of the natural features and landscapes. I propose qualifying that policy with consideration is given to adding the words the characteristics, qualities and values of the O&M. Again, drawing that down from the objectives and policies above. So really it's the assessment is targeted to those matters as is directed in the policies above now under section 42.84.
When you look at that wording, some of the earlier material we've heard this morning, they've talked about the characteristics and qualities of the values, rather than characteristics, qualities and values. Talked about characteristics and qualities of the values. Is there a distinction need to be made?
There is, but I must, I line them up together because they're used interchangeably, and I suppose the starting point for seeking that particular change in the relief submissions was looking at the worksheets where, so that's from a consenting point of view. So if I'm to look at a proposal in relation to a O&L, then starting point or one point would be to go to the worksheet and see, okay, well, what are the things that I have to look after? And characteristics, qualities and values are used interchangeably in those worksheets and in the higher order policy documents. So I think necessarily they will line up rather than characteristics, qualities of the values. That's a
Yeah,
different
so
concept.
what you're proposing here, characteristics, qualities and values, we take it that that's correctly what is being sought.
Correct.
Thanks.
So there's been a couple of other minor changes to that O&L policy in FLP8, where at D there's a criteria, I call it criteria because they are in effect criteria, that read any means of integrating the building or structure or activity, and I've sought to add into the wider landscape. Because it's the sentence is almost incomplete, integrating the building structure activity to what is kind of what's next. So that's why I've recommended into the wider landscape. The next one is at F, the need for and location of earthworks or adding indigenous vegetation clearance. So at the moment, that part of the policy refers to earthworks for vegetation clearance, and I think for consistency should say indigenous. The next, again, that's question of characteristics, qualities and values that Roman J of that particular policy, the characteristics, qualities and values, to add that. And then the next one to add to the landscape policy, which is the one I'm talking about, EFLP8, a new matter, which is P, whether the activity is on a previously approved building platform. And this is one of the recommendations that comes through in relation to the coastal environment. And I think it usefully applies also in the O&F chapter as a matter for consideration. Turning then, lastly, a very small matter at O, visual effect of the building structure activity. Currently it talks about on nearby ridgelands, headlands or peninsula. And again, I think my suggestion is that in relation to nearby ridges, headlands or peninsula, is better when considering an effect of an activity.
With regards to P, if it was previously approved, I mean, you could just say an approved building platform. An approved building platform is something that's part of the existing environment. Doesn't necessarily need to qualify previously, because I don't think previously.
I agree, it's either approved or it's not previously.
Yeah.
It's not, in fact, not necessary.
Yeah, it could potentially confuse someone, I think.
I think I was just picking up on the point delay work in relation to the coastal, but yeah, so I'd agree in relation to that coastal policy and this policy.
To say an approved building platform recognises something might be part of an existing environment.
That's the intention.
Does that also need to specify building area? The two you were talking about?
It does, yes, all buildable area.
Buildable area.
Yes, yeah, quite right, the same thing. So those, as I say, they're minor refinements to those consideration policies. The next topic I want to turn to, if you're in my evidence, it's section 6, is the policy in relation to farming, and just to confirm, I support the changes recommended in the 42A report in relation to these policies and the provisions that follow, but just seek a change to policy CEP6, which is to enable farming activities in the coastal environment, which I support. My suggested wording is to delete the phrase where appropriate, and so at section 6.7 of the evidence, the amendment I propose to policy CEP6 is delete where appropriate, and the basis of that is that
What I'm doing is I'm following along, I'm actually in your attachments.
yes,
Okay, so CEP, that's on your page 2 of 11 of your attachments, right? Oh, yeah, I found it.
you got that?
Yeah. So as you're reading your evidence, I'm trying to follow your amendment.
Okay,
Your amendment of the
Yes.
council's amendment. So
And so I'm proposing to delete the where appropriate, on the basis that outside high natural character and outside natural character in the coastal environment, the policy presumption should be that farming is appropriate because it's provided for. Just picking up on the earlier discussion, clearly there are still controls on earthworks, location of buildings, vegetation care, and so on and so forth, but those controls sit aside by themselves. Turning then to the Indigenous biodiversity chapter, and just sort of working it out.
That follows your coastal one?
It follows the coastal one, so in
Yep, I've got it.
with that, there is a new policy recommended there.
You made a change to the overview as well? Change the will to a name?
I do. I need to check on that. I'm not sure whether that's my change or the 40 to Asia.
So where was that, sorry? Oh, so it's in red.
I know, yeah, that might be.
This is in the overview to the NPS, for the IB chapter, Indigenous Biodiversity chapter, and it's in the third paragraph. And third paragraph, 1, 2, 3, sorry, the third paragraph, 1, 2, 3, fourth paragraph, fourth line down. Are identified through ecological assessments in accordance with the significance criteria appendix 5 of the RPS. There will, struck out, may be greater control over land use. Who's changing it? Do you want to own it?
I'll have to reach again to remind myself I changed it. So where areas of significance as far as vegetation and clearance habitats are identified through ecological assessments, it's there may be gaining control over land use and subdivision. That's because there's no rule set that says that. There's no rule set that specifically follows through that there will be gaining control. There may be gaining control as a matter of assessment.
Okay, thanks.
Okay, so then the other change I was going to talk to on this topic was that the new policy IBPX, so it's just an X because it doesn't have a number yet, as recommended by officers. As the 42A recommended, it is to enable subdivision of associated land use where this results in, as it was recommended, the legal protection and or restoration of areas of significant Indigenous vegetation, significant habitats of Indigenous fauna in accordance with sub R6, subdivision rule for environmental enhancement subdivision. Now, I support the broad thrust of that, but consider that at this level and in this chapter, the plan policy should be cast. And so I recommended that where it results in the restoration and enhancement of Indigenous biodiversity, including underrepresented ecosystems and where biodiversity is increased and legally protected. So a couple of reasons there. One is that it should not, in my view, be only limited to significant Indigenous vegetation and significant habitats of Indigenous fauna, but it's ought to be restored or enhanced. In other words, restoration and enhancement may take a piece of some degraded Indigenous habitat or fauna and get us to a state of significance. And that probably should be the goal. But the policy provision should, in my view, support the enhancement of Indigenous biodiversity wholesale. And also it should not, in my view, be limited to that fauna and habitats in accordance with subdivision rule R6. And I make the point in my evidence. There is another subdivision rule, management plan subdivision, subdivision rule R7 in the plan, which the submitters and we will be coming to talk to you about later next year, which also seeks the enhancement of Indigenous biodiversity not limited to significant biodiversity only. And again, the principle of that is that through such action, the values of Indigenous biodiversity can be enhanced. So I pitched that policy at that high level. So then turning to the controlled activity on a defined building platform, probably in my evidence that the bit of the roadmap, I suppose, the steps of this paragraph 8.6.
You added a whole lot of ors.
I added a whole lot of ors. Simple.
Are they your ors?
They're mine. Yep, thank you for that. Just they picked up on that or technique was used in one set of the changes recommended, but not all. And I think it usefully follows. Otherwise, you don't know whether. Well, you do through interpretation of the provisions, because the or on the end. But I think usefully each of those clauses has an or because they all apply.
Yeah, but I mean, yeah. It's often when people are using semicolons, you just run your list and then the or an and happens at the bottom, but you think it needs to happen at each step?
And it's a very small improvement, but yeah, it's exactly what is happening with one of the set of provisions that is recommended by officers. A whole lot of semicolons and an or at the end, and in another set of the provisions there, an or after each semicolon, which is just, in my mind, makes it more readable.
If I may add a comment here, this has come up through drafting with the whole wider team of slightly inconsistent around how semicolons are used, and we just agreed as a team if you were wanting it to be a or clause, as it's an or at the end,
Yes.
or you want it to be and everything needs to be if it's an and at the end. And that's sort of what we agreed moving forward. So that can be clarified in the intent in the start of the plan, but that's the intent of those clauses.
Well, Mr. Harrison, while you're here, is there anything legal that turns on the own use of the clause?
Your district plan is a status of a regulation, and so your interpretation legislation applies. It is the usual convention is that if you've just got an and or an or at the end, then it does apply to everything. But what I think Mr. Hall's identifying as an issue of consistency across the district plans, I think that would be resolved.
So that can be resolved by removing a whole lot of rules elsewhere.
Yeah, the concern is if you've got it in two different places, later on people like me are going to try and argue.
They're wanting a different outcome here because they've used these laws everywhere.
Exactly.
Yeah, but we would be equally concerned with that as well. Okay, well, thanks. So you guys, council officers.
Mr. Chair,
So the question is, you want to be consistent, right?
I understand we've undertaken a clause 16 to actually implement what Mr. Wyeth has talked about. So
Right.
the plan has been amended to reflect that.
Yeah.
I'm happy with that. I think, as I say, it was just coming up with a particular recommendation, probably the one I was.
You saw it elsewhere.
I saw it elsewhere. So in the
Whereas I think
natural landscapes feature section.
whereas I think the consistency change that they're referring to when they wanted to use clause 16 for is to use the or as the last.
Indeed, yeah.
What's the last semicolon?
Yeah, just to point out where I was getting that from, it's NFL R3 and 42A, it was used or so I followed the dots. But the short answer is, as long as it's used consistently, then I'm sure happy.
Okay, well, yeah, I think we'll move on. And I think you've proposed another 15, 15 there, the end of PR1, PER1.
Yes, and I was going to talk to that when I was talking to my section on planting Indigenous vegetation and domestic gardens. So yeah, that's correct. That's that in effect repeats here and repeats in the other overlay section as well. Yeah. So the next topic I wanted to talk to was the controlled activity building within building platforms or buildable areas. And so at 8.6 my evidence of summary, I suppose, specific changes I'm seeking to that. And these are refinements
So that controlled activity is in what section of?
It appears twice, so it's kind of the nature of these chapters that we're dealing with in a couple of places.
The first one?
The first one is natural features and landscapes and evidence, and that is rule NFL R1.
NFL comes before coastal?
Yeah.
I'm just trying to get to, I'm just going to get to more. Okay, NFL R1.
And then the next time it appears in the coastal environment chapter at CER1. So the two R1 rules, both of those are placed. And the wording is the same, so we talk about both and seeking the same thing both. So the 8.6 evidence, the first change I'm proposing is that it recognises entitlements and underlying zoning for both residential units and minor residential units. And at the moment, the recommendation from the 42A is that the building is a residential unit on a defined building platform. I'm proposing that it's for a residential unit or a minor residential unit. My rationale there is that the proposed plan provides for residential units and minor residential units. I'm reflected on the Ms. Absalon's report in relation to the domestication of the landscape, and that outcome of confining residential activity for a building platform is still achieved, no matter how that is used, whether it's used for a residential unit or a minor residential unit. Then the other thing I'll just reflect is that the minor residential unit is defined on the plan, maximum 65 square metres, no further than 15 metres away from the principal unit. So in effect,
Will it be on the same building platform?
it'll be on the same building platform.
Yeah.
So I think that objective of confining domestic activities as a controlled activity to the building platform is still achieved where both residential units and minor residential units are used.
Would it, because when I first read it, I was thinking, are we talking about separate building platforms or the one defined one? Would it
It's the one that defined, that says the building.
say something like on the same building platform, with the same defined building?
The building is for a residential unit or minor residential unit on a defined building platform. So I took
And the same.
a residential on a defined building platform.
But you mean, yeah, a single defined building? Maybe that qualifier might be justified.
It wouldn't hurt.
Yeah.
The next
You set out some matters of control there.
topic is to cover the matters of control, and you know, as I set out in my evidence, as recommended in the officer's report, the matters of control currently point you back up to those consideration policies, and they are very broadly cast. So, for example, requiring an assessment, although these are matters of control, presence or absence of buildings or structures or infrastructure, the ability of the environment to absorb change, any alternative viable locations talked about before, the opportunities to enhance public access and recreation. These are all matters that have been, at this point in the development process, dealt with already. And remember, what I mean by that, at this point in the development process, we've achieved a subdivision, we've had building platforms, buildable areas identified by professional landscape advice. And so those fundamental questions of location, density, broader scale mitigation, avoidance of various values, they've been dealt with in subdivision phase. And so, in my view, the matters of control need to be more tightly defined, and so I've recommended those in my evidence here. The matters of control are the location, scale and design of the buildings and any associated accessways and infrastructure, having regard to their visual prominence. Secondly, the means of integrating the building structure activity into the landscape, including through planting. Thirdly, the height of retaining walls, their colour, whether planting is necessary to mitigate visual effects, and D, any mitigation measures proposed as matters of control for the council too. to assess applications.
So the external materials, would that be covered there?
Yes, at two levels. So the design of buildings, but moreover, there's still development controls to be applied with. So development controls in relation to materials and colours, those standards still apply.
They're up to the side?
They're up to the side. Okay. As does height, et cetera. So those development controls still apply in this regime. So that's that one. Next topic is next one I'm seeking a change on is clarify that the rule applies to existing and implemented subdivision consents. And so the rule as drafted refers to approved as part of an existing subdivision consent. And I suppose if we're thinking what is an existing subdivision consent, and does a subdivision consent continue to exist once it is implemented? And it's actually, that's the part that we're thinking about at the moment. It's the post-implementation of the post-obtaining of titles and the ability then to ensure that, subject to the buildings being within defined building platforms, that control activity status is obtained. Now, I think I understand the reason for including approved as part of an existing subdivision consent, because I suspect the councillors are not someone coming along with lapsed subdivision consent and saying, I've got different platforms. So I'm sort of supposed to build on that to say existing or implemented subdivision consent. The next one, as touched on in this area, to make it clear that such applications will be dealt with on an unnotified basis unless special circumstances apply, which is what the law says at the moment. But just effectively looking to future-proof this provision should the law change. And again, that is on the basis that fundamentally that subdivision and those fundamental issues of scale, form, location of the subdivision and buildings have been dealt with already through a process. This is about the buildings on the building platform. And then lastly, as I've talked about already, add an addition to the building platform or buildable area, as we discussed. So that's the controlled activity. Were there any further questions on that? I'll move to my next one, which is section 9 of my evidence, which is around activity status for buildings, extensions and alterations in an O&L. Talking about an O&L. So there's two key changes here. First, at 9.2 in evidence, I favour discretionary rather than non-complying activity status here for buildings, extensions and alterations in an O&L. If they do not otherwise control activity on the defined building platform. And my reason is that discretionary activity still allows consideration of the bottom line policies referred to in the section 42A. And important here is the overriding objectives of O&F and protected from inappropriate land use and subdivision. And that, in my opinion, warrants a merits-based assessment as to the appropriateness of a new building or structure in the coastal environment as it take place in a discretionary activity assessment. So, looking at that in relation to the New Zealand Coastal Policy Statement and RPS at 9.4 evidence, I make the point that they do not present a policy construction which precludes or assumes against new building constructions in the O&L and coastal environments, particularly recognising that some O&Ls are lived in and modified landscapes, and there may be a reasonable expectation to build on a new dwelling or rebuild an existing dwelling. There's a distinction though between O&Ls and O&Fs. So O&Fs areas are mapped in a very strict way and limited way, which is by nature are throughout the coastal environment. And I think it's fair to say there's a reasonable presumption that buildings and structures would probably not be located in an O&F. In my opinion, non-compliant activity status appropriate applies to new buildings and O&F areas. But I'll make a distinction with O&L areas, where in my view, because of the broad nature of their mapping and the broad and varied nature of the landscapes, then a discretionary activity captures all that it needs to capture for the council. I guess that's just a broad thing of pitching the activity status to its most appropriate. And on a similar theme, the second part of this section, my evidence, I make a distinction for new buildings or structures or extensions of buildings located on sites in the coastal environment, and where the entire site is included in the ONL, which is a circumstance that does exist. In these cases, in my view, there should be a reasonable expectation to be able to build on such a site, except in that special regard still has to be had to the effects of the characteristics, qualities and values of the ONL, location and design. And so I'm proposing a restricted discretionary assessment in relation to those matters in those circumstances. And I have referred there also to the Whangarei district plan, which includes that rule where restricted discretionary activity status is applied to buildings or residential units in the ONL within the coastal environment where an entire property is included within the ONL. And again, given those consideration policies that the restricted discretionary activity assessment would take you to, nothing would be lacking in that assessment in my view. Turning then to earthworks and indigenous vegetation clearance. I suppose that there's three changes I'm seeking here. So those are set out at paragraph 10.1 of my evidence over the page, and these have been incorporated into the overlays in my drafting. So the first exclusion is for a maintenance of planted indigenous vegetation in domestic gardens, including the removal and placement of plants. I think the comment was made in the 42A report that 50 square metres per year would be enough to maintain such a garden. But I think the thing to remember, of course, that indigenous vegetation is protected in the plan without limit, in other words, height limit or otherwise. And so an area of flax, tussocus, those type of typical native vegetation gardens would be captured by the rule. And in a normal part of gardening, certainly part of my gardening, you make mistakes and you do things again. So doing things and turning things over as part of domestic gardening, whether it's indigenous vegetation or otherwise. 50 square metres could be put in terms of, for example, 2 metres by 25, which is a stripped down driveway. So it's not a huge allowance. And I think, as pointed out by Mr. Goodwin, there's a clear distinction between the natural character aspects of naturally occurring vegetation and that is planted. And so we worked together on the particular exclusion to make it as tight as possible. So maintenance, for a start, of planted indigenous vegetation within domestic gardens. So it is planted indigenous vegetation. It's not indigenous vegetation that's naturalised. And so I think planted is very important to include there, and also within domestic gardens. The first exclusion sought there. The second one is formation of a walking track less than 1.2 metres wide using manual methods which do not require the removal of trees under 300 millimetres in girth. So those specifications come from the Indigenous Biodiversity chapter exclusion. I'm seeking to apply them to the other chapters at the moment. And I think our site visit to the Yates property certainly brought that need for such a thing home, where as is typical in coastal indigenous vegetation looked after properly, it's very dense, and in order to get to it and through it, including for pest predator control, maintenance of trap lines and the rest of it, you do need to cut a track. And so this is that balance, I suppose, of avoiding adverse effects while equally enabling restoration and enhancement. And so that's the primary purpose of that tracking allowance, and again, very deliberately targeted to using manual methods, I think, is an important part of that. So that sort of say prevents the bulldozers coming in. We'll have to be pretty narrow with bulldozers at 1.2 metres, but you get my point. And then lastly, the maintenance and reinstatement of pasture through the removal of regenerating, and then I specified the species regenerating manuka, kamuka, tree ferns and rushes in pasture on farms that were established prior to this date, and that date is the same date I think used in the Indigenous Biodiversity chapter, was the notification of the plan in effect. And again, this exclusion is sought to apply throughout, including the overlays, and picking up this point made by Ms. Abson, which I agree with, the natural re-establishment of native vegetation and within coastal areas and in Ōmāpere is important, but this is not that. This is the colonisation of pasture by grazing resistant species. That's the distinction sought to be made here, which is talking to some of our farming clients, a big part of their working day, maintaining pasture in that way. So it's not seeking to allow an all-out clearance of naturally revegetated vegetation that's coming in. It's simply allowing the removal of that indigenous type of vegetation which is tolerant to grazing and therefore pops up in pastures no matter what. So that's the purpose of that distinction.
How do you prove it's less than 10 years old?
The easiest way to do that. So the less than 10 years old is borrowed from the Indigenous Biodiversity chapter where they have that same clause, except there's a general allowance to remove Indigenous vegetation in that circumstance. I've refined it further in these coastal and outstanding landscape overlays to be those, narrowed down to be those grazing tolerant Indigenous species is the purpose for that. Yeah, so that's the reason for that exclusion short down. Now, turning to the next part of that particular discussion at 10.7 of my evidence, where this is the consent trigger for earthworks and Indigenous vegetation clearance in O&Ls and ONFs where compliance is not achieved with the standard, and as I read provisions at the moment to go above the standard into non-complying activity territory. Now, my proposal is that a restricted discretionary consent be used in those circumstances rather than non-complying in the coastal environment, really seeking to strike a better balance for the need for proper assessment of the effects of values, while recognising that there may be many circumstances where non-complying consent applications would be warranted and not unreasonable. And then again, that restricted discretionary assessment, I'm proposing that reference be made back to that consideration policy, and so that's a broad a range of assessment matters there, so I don't think anything's being left out there. But I accept it is the nature of setting a rule, but at one end of the spectrum, as I pointed out in my evidence, cut faces over only slightly over 1 metre would trigger non-complying consents. Being exposed cut face being not being screened from public view, no matter the distance, would require a non-complying consent. Clearance of Indigenous vegetation exceeding 50 square metres, 51 square metres would require, on a very large property, no matter the size of the property, would require a non-compliant consent. And as I say, I accept it as the nature of setting a rule, and you could equally point to much larger exceedances and say, well, non-compliance is appropriate. But as I say, given that it is in effect a development control standard, in my view, restricted discretionary is a better activity status for that and strikes a better balance. And then just the last point on that, the particular issue here also is that earthworks and Indigenous vegetation clearance are often a precursor to development such that non-compliant activity status will spill over into the development of the whole. An example would be building on one of our controlled activity building platforms and undertaking earthworks simply for the purpose of forming that footprint, which invariably would exceed 50 square metres, so invariably would throw the activity as a whole into non-complying.
Just under the definition of earthworks, you brought up the claims of indigenous vegetation, you talked about earthworks as well, no matter the size of the property. And then you've also talked about farming activities and it being provided for. So based on what you've said, if there was a 200 hectare farm, if they did 50 cubic metres on a farm, like to maintain a laneway, for example, that would be a non-compliant activity for that.
The 50 square metres in excess of that in the coastal environment in an O&L, irrespective of the size of the property is, which I think is part of my thinking for is that activity status set pitched at the right thing. Because ultimately it still has to be a question of assessment of scale and degree, and within this wider property is that appropriate.
And that's the same for, as you said, if you've got a defined building.
And that's the same, there's no exclusion for a defined building platform.
Your point.
But I think you've got a little bit more to take us through, is it?
A little bit more, but to be fair, I've got one last topic on there, so.
I was just thinking whether we take a break now for a slightly shorter lunch, maybe 45 minutes, and get you to wrap up and ask some questions.
Yeah,
box on to 1:30.
The last topic is maximum height, and it's going to take me all of sort of 4 minutes, 3 minutes to talk about, and then.
Let's do that.
Okay. So two amendments sought to the maximum height limits, and 5 metres has been discussed and recommended by officers. Although it's not directly recommended by either landscape expert, I'm proposing a 5.5 metre maximum height. Firstly, to provide a degree of flexibility to provide for sloping roofs. Secondly, it's to reduce resource consent requirements as opposed to the purpose for that. And so my thinking here is to pitch that height limit to its upper height level, which still achieves the generally one-storey outcome, but avoids the need for a whole bunch of little bits and pieces, resource consents, and invariably come with rolling height limit as it cuts down the face of buildings and what have you. So I've been really trying to find a balance between that outcome, which has been discussed by the landscape experts, and a height limit that doesn't trigger unnecessary resource consents. And again, with reference to other district plans, Whangarei and the exposure draft of the Kaipara district plan, both 5.5 metre height limit in these circumstances, O&Ls. And then lastly, I recommended some exclusions to the maximum height limit control. And this is in part, might be a victim of the National Planning Standard approach, where the definition of height is the definition of height without exclusions, simple definition of height. There are exclusions provided for in each of the zones for things such as solar water heaters up to 0.5 metres, chimneys up to 1.2 metres, satellite dishes, architectural features up to 1 metre. You know, all normal things that protrude above a building. And I recommend that those exclusions also apply to the 5 metre or 5 metre height limit, which is in the overlays that we're discussing today. So simply again to avoid the need for unnecessary resource consents. And my reading of the plan is done otherwise applies, so I recommend that specifically do. And that's the end.
That's everything. I didn't do that.
Oh, sorry, sorry, Mr. Goodman has reminded me. I got one more, so I promised. But there is one more, and it's natural character rules relating to wetlands and lakes and rivers, and I'm proposing a change to the definition. This is the lake, not question of lakes, and so that's been recommended.
You've added or constructed
farm water supply, and picking up on the
Read it back.
discussion.
in multiple clauses.
I have, and the purpose of that is deliberately use the word constructed farm water supply because they may be constructed for a certain purpose, they may be fenced, they may develop a degree of natural character, but ultimately they've been constructed for a certain purpose. Now, the definition recommended is sort of limited 1 hectare as that when it lake under these provisions. Now, the operative plan has 5 hectares and in lieu of any evidence to say one way or the other, I really haven't landed on whether it's 1, 5 or somewhere in between. I think usefully though it excludes dams or lakes, dams constructed for farm water supply purposes. Be it stock water or drinking water because they can also be used for drinking.
And the hectares, that's a pretty good sized body of water.
It's a pretty good sized body of water, but of course, like any plan control,
Bigger than your average farm dam.
it says nothing about the quality of the shape of it, which is probably more important from a character point of view. So I think constructed is the most important, constructed for farm water supply as well.
Okay.
Thank you.
Well, I think we'll just see if there's some further, I haven't got any further questions for you, but starting with you, Mr. Keating, Commissioner Keating.
Yes, one on the 5.5, that you're recommending the height limit. Seems to be the main reason you're recommending it, and that's in your evidence, is the reducing resource consenting. Does that go against the whole, in these special overlay areas, the whole landscape protection, starting point, which the landscape architects are talking about, saying you do need that kind of level of assessment above that 5 metres. You've gone against both of the landscape architects' recommendations in that case. And is there anything more to it other than reducing consenting?
Well, that is key to it. But I suppose what I'm attempting to do is accept the recommendations of the landscape architects that the general objective is to maintain a generally 1 metre, one level building.
Yes.
Within that 5 metre. But then say, okay, well, how far can we push that before it becomes a 2-level building? So it's not 6, and strike a balance between the two. Accepting, as is pointed out by Mr. Goodwin, that invariably in these environments you're on a sloping site and you have a rolling height limit which comes down and follows the land behind, and so it's very easy to have to clip off the front of the building to comply with the 5 metre height limit, and really just looking to ease it up as much as you can to avoid resource consent requirements, most definitely, in those circumstances, while still maintaining that landscape objective. Now, it might be theoretically possible to squeeze 2 levels into 5.5, but I'd say, well, the difference between 5 and 5.5, what is the harm?
Half a metre, it's not a lot, is it? But,
No.
Is the issue. I mean, is it enough to force the issue, I guess?
Yeah, and I think, as I say, just also reflecting on there is general desirability for consistency in these things across districts.
Oh, that's interesting.
Yeah, reflect on the adjoining districts.
Okay. Thank you.
Can I just pick up on that, just without interrupting your question? I think just on that particular question, while we're on it, I actually think what you're saying really underscores, or it basically contradicts what you're talking to us about and all the rest of your evidence, because you're basing your evidence quite fairly on the landscape evidence and talking about the values, characteristics, features, etc. and the like. And then it seems to be as a matter of administrative convenience, oh, by the way, while you're looking at those matters, let's knock half a metre off that particular standard. As I hear it.
No, not at all. That is Section 32 analysis. That's my job. So to assess the costs and benefits of the provisions and their effectiveness and efficiency. And I'm saying that yes, I can see the objectives of the landscape evidence, and that will come with a cost, and will come with a cost of regulation, which is a cost on both the community and the council. It's a cost of regulation, seeking to reduce the need for that regulatory burden and consents that come from it to the greatest extent possible, while still maintaining what I interpret the landscape architects are saying. So no, I don't think it's contradictory. It's taking their advice and turning that into plan provisions, which is the stuff of planners.
I guess what I'd say to that then is, are you going to provide evidence of how many applications the council receives that take you into that ambit or that area of the extra half a metre?
Well, no, it's a bit difficult because we're not in a 5 metre height control regime at the moment. It's 8 metres in these environments under the operative planning. So,
Okay, thanks.
I think there's only one more question that I have that comes out of that as well, and that's a question for yourself and to the council planners. Does the plan enable an average height method?
Not currently in these overlays.
No, so you were talking about rolling height, so rolling height is the only circumstance in which we would calculate height?
correct, and that I think is a national planning standard direction. It's how the height is defined.
Yeah. Any other questions arising? Okay.
I get the impression the chairman doesn't like any more questions. That's a compliment.
Let's have another 20 minutes of questions. Okay, well, thank you very much. We wanted to spend some time on your evidence.
Thank you very much.
It actually is very clear because of all what you're setting out and we followed it reasonably clearly, and so thanks very much. We've gone a little bit over time. I think we'll just take a 45-minute lunch break. Well, we'll be back with a 2:15. Get in touch with Mr. Badham, who's supposed to be up. He's, I think he's had lunch now. It's 2:15, and thank you very much, and we'll be adjourned.
There were no further questions. I know there was a question of whether there might be some questions arising for your evidence once you've heard Mr. Hall, so I just thought I'd just double check before we go. Okay?
No further questions, Mr. Goodman.
Thank you, Mr. Chair. Stopping recording.